Ladies and gentlemen, it is my great pleasure to announce a talk by Marie-Claire Foblets with a topic nobody would expect from a legal anthropologist. Because she wants to plead for state law to embrace complexity, so that means that all the manuals about legal anthropology were wrong, telling us that it is just about the non-state law that legal anthropology is interested in, and all legal sociologists, jurists, and so forth are doing all the time the same mistake to take the state law for the reality of the realm of normativity. So this will be, even the title makes us very curious. And there are more reasons to be very curious, because Marie-Claire is not only trained in law, but also in philosophy, in anthropology, in social and cultural anthropology, and finally in legal anthropology, where at the Max Planck Institute for Social Anthropology, she is in Halle, at Halle, she is responsible as director of the Department of Law and Anthropology. Since 1 year and a half, yesterday evening, she told me it is 1 year and a half, and I said, no, that's not, it must be for many years. We have been so often at our center to give a lecture or a talk, and reciprocally we visited with her at Halle, so this can't be possible. So a lot of things that are going around your effervescent personality. So excuse to be that person. Oh, okay, that's very bad. I excuse myself for this. The last book. The last book, it's a rather heavy one. Approche juridique de la diversité culturelle, legal approaches to cultural diversity. This is in the center of our interests of this conference, and certainly relates also to the topic you are dealing with in a global context. I would like to mention, besides this one, edited together with Najma Yassari. It's very recent, and I will leave it here, but I will take care of it, but you may have a look into it. It's really an important approach, and approaches in plurality, plural approaches to the questions of plurality. I would like to mention at least one further publication, and this is Les familles maghrébines et la justice en Belgique, anthropologie juridique et immigration. So you will say, this certainly must have been published in 2002. No, it was 10 years before. That means you were really in the forefront of the people who were interested in the question of Europe, and you continued on this line. How this will be reflected in your talk today, I'm very interested in, and I'm curious really to listen to you and to share once more your knowledge. Thank you.
Well, after these two brilliant presentations of this morning, I think I will rather speak of not a third kind of exposé, but I will testify. In fact, I will share with you a concern, and I think I will come very close to you, Paul. So I'm so happy that we met here at this conference, and I have to confess I didn't read you, but the first thing I will do back in Halle is I will look up for you as an author. Now, Werner, you had to convince me to come to this conference, that you remember, but as you are so often successful in convincing people, you managed. But I had my hesitation, because the two previous times you invited me, I could really kind of elaborate, introduce people into ongoing empirical research. And my hesitation had to do with your invitation came, so to say, at the wrong moment. I'm still with empirical research, but not far enough to present it here. So, in fact, you made me think, what could I then do? And what I did, I started writing a piece. And in fact, I'm very happy that you made me start. It's for me like in French we say un état des lieux. Where do I stand with regard to law and diversity? Where do we stand in law? And I have probably to justify. It will be a plea, it will be a plea for state law, it will be a plea for embracing, and it will be a plea for embracing complexity. What my piece will be like, it will be a distinction between what we call in law de lege lata, de lege ferenda, the law as it stands, and then what could be a better law, no? the law that is to be elaborated. I will not base my presentation, as I said, on really empirical research, but I will draw on legal practice. No? And I will, but that I probably can't do now, but for the days and the weeks to come when finishing my piece, I will draw on some of your work that was presented so well here the past days. So I'll try to do my best, and of course you will then know Werner. But 2 points of clarification first. Which complexity? Complexity that comes with increased cultural, including religious diversity, because law is faced with other types of complexities today. Think of all the technology, communication, media. I think in particular of a specific technology that has to do with procreation, the potentials of designing a new baby, and then the people that in Europe shop around for the most kind of lenient legislation. So if you can't have your baby made there, you go for a baby elsewhere, and it's being covered by the case law of Strasbourg. So it's fine if you don't have it in your country, you can have it in another country. No, I'm not facing this type of complexities. I'll do it for cultural diversity. As I said, it's work in progress. I did present the very first version of this paper at a meeting that was convened by, and unfortunately it's not here, Thomas Douve, no? Rechtliche und kulturelle Vielfalt, Diversitätsforschung. And as you will see, I will be a little bit embarrassed because I did prepare slides. I don't know whether I will use them. I have a text and I don't know how far I will remain reading or be a bit more spontaneous. Let's see, but I will be a little bit troubled for sure. The second point of clarification is, and here is really what you were already mentioning, is this an anthropologist or is this a lawyer today? No? Today it's the lawyer probably. In looking for the better law, the lege ferenda, no? I've come for myself to the conviction that it better be legal solutions that in one way or another can be brought under the umbrella of what I call state law, and in legal anthropology what you could call weak legal pluralism. A state law that is respectful of the rule of law in the fullest sense of the term, because if you have to do with a corrupt state law, that's my plaidoyer will not work. I'll try to make clear why I see more benefits in diversity being granted some form of recognition formally by state law instead of strong legal pluralism options with no institutional structural arrangements in fitting minority laws, practices, beliefs within the broader picture of what is known and then acknowledged to be state law. The background. Among the expressions of cultural diversity that pose the most kind of intricate challenges to law understood as legal practice are this kind of increased multi-ethnic, multicultural characteristics that have become really core characteristics over the past 30 years of our societies. No? Various new, still called alternative forms of affiliation, of belonging, whether ethnic, cultural, religious, individual, and here's my point, seem to cast a shadow on social cohesion in the conventional liberal sense of the term. How often was it being quoted? Multiculturalism has failed. From an ethnographic point of view, cultural diversity, it's irreducible, it's a phenomenon, it comes with mankind, so far so good. But today, diversity, as it is understood in the public discourse, seems ever more frequently to have become an obstacle, which in turn tends to give a new meaning to the role, and here is my point, legal techniques could play in this area. This is to remain the guardians of social cohesion. I think here is an opportunity not to be missed, and then looking for what are the appropriate legal techniques to guarantee social cohesion. I quote, "Policies of tolerance and multiculturalism should not be applied uncritically." That was the reservation expressed a few years ago by a Dutch author, Yvonne Donders. To a certain extent, she's right. But what is the right balance? While a critical attitude towards some, and you said it, Paul, some cultural communities in particular, is necessary to protect some individuals even against their community, this critical attitude should not lead to a rejection of cultural rights or cultural identity as a whole. But the opposite is true as well. Cultural identity should not be used to excuse or tolerate practices that violate, for example, human rights. Or to put it in a somehow more pompous way, the effort to be put in place or to put in place legal mechanisms to guarantee the protection under state law of cultural diversity and deals with, in particular, minority cultures should come with the promotion of human rights. So, which attitude should, and I insist on, state law adopt, where it does not yet actually do so or not appropriately do so in the face of multiplication of identity claims and increased diversity at large? Can, and if so, how can laws be placed, so to say, at the service of a search for justice within an as fair as possible plural society? That is to say, maintain sustainable kind of peace in society, but taking into account increasingly diversified cultural identities, as I said, be they ethnic, linguistic, religious, philosophical. And in some countries today, experiments with regulating the interactions between positive state law and other existing normative orders, I would say, are quite audacious. I think, I don't know whether I'll have time to just dig into this kind of experimentation with religious arbitration in Britain, granting the status of nation to indigenous communities, for example, in Canada, far-going forms of reasonable accommodation, for example, when state law accommodates religious practices, freedom of education, far-going but protected under state law. I think we should go for this kind of, in my view, sustainable way of thinking of diversity under the umbrella of the state law. Should one then speak of the failure of the state, failure of multiculturalism? This is very much what I would like to contest. There is the fear in the public discourse that once you grant some minority rights, you get easily these parallel normative systems, you lose the control, and in the end you reduce the rule of state law to a merely supplementary legal order. Ideally speaking, and I can't repeat it enough, state law should be able to remain unitary to a certain extent while allowing for the coexistence of other norms without feeling threatened. However, as I said, there are divergent views on how then to reach this ideal. When you look at the case law, and I think the case law for good reasons is a very good source, because the courts cannot delay their decisions. They have to take a position. The courts tend to be prudent, rather prudent, especially where the cultural argument, in their view, boils down to a defense strategy without offering sufficient guarantees that one is truly, authentically dealing with respect for a person's sense of belonging. Culture becomes then a strategy. It has more to do with profit maximization than with a real search for justice. So the courts tend to be prudent. Now, so far so good for my introduction. When you think of how do you then best analyze when law faces cultural diversity, I think we should speak from complexities and see that depending on within which type of situation you are to deal with cultural diversity, the legal reasoning will by necessity be different. And I think that here lawyers have a responsibility, because very often then the law is taken for one box with all the arguments that, no, depending on the setting, you don't always have all the arguments. So I, for myself, think of an analysis of 3 times 3. Namely, you have to distinguish 3 levels of analysis. At which level are we dealing with cultural diversity? I think we have to put 3 very concrete questions, and we have also, well, I could maybe distinguish more, but so far I distinguished 3 trends, what you could call convergences. And my concern is that we have to distinguish, because the legal reasoning, depending on the level, the question you put, and the trend you observe, will turn out to be different. Let me be very brief but clear on that. The 3 levels of analysis. you have the global, you have the regional, and you have the local, and that may be domestic, state, or even lower than the state. The techniques are different. The competences are different. You don't necessarily have the same binding force at the global level than you have at the local level. No? Do you have bodies that are controlling? Do you have sanctioning mechanisms? No? If you look at the global level, with the work that, for example, the UNESCO have been doing with the Convention on the Protection and the Promotion of Diversity of Cultural Expression, it looks like there is something like a new principle at the global level, which is respect for cultural diversity. In Europe, we are facing really the problem that the sovereign states are on the one hand member states, and we promote freedom of circulation, freedom of values. And on the other hand, you see how these states are trying to make the principle of subsidiarity the really last security bell against freedom. So you have this, so thinking of cultural diversity in Europe, you cannot explain to an outsider, I would say, because it's so intricate and it has to do with our own past, but we nevertheless want to become a transnational legal order. And then, of course, at the local level, all countries have their own way of thinking of cultural diversity. But there, you have the maximum of the competences very often, when it comes to culture, when it comes to education, when it comes... So I think we have to distinguish these three levels. Three practical questions. It sounds very kind of like a class, but it's for myself that I'm trying to make clear the picture. In which setting are the people thinking of cultural diversity? Is it, for example, within a minority group? Or is it a mixed group? Is there a kind of factor of dominance or not? And your reasoning will be very different. No? The origin of cultural diversity. It may result of voluntary but also of forced migration, and it may instead have to do with legal transplants as a consequence of colonial occupation or globalization more generally, to mention but a few explanations. And you will see it weighs on the legal reasoning. If people feel that these newcomers are imposing their values, whereas we cannot grant them the status of national minorities, we don't identify with them, this produces a totally different legal reasoning than if you have to do with indigenous people, with the feeling that your state has been imposing itself upon them. No? So the concrete, the origin of the cultural diversity also weighs on your legal reasoning. And these two, the setting and the origin, will, and that is then the practice, produce another dialogue. The interaction between state law and the cultural differences will turn out to be very different depending on from which past this origin, this diversity is being perceived. And ultimately the three questions together, I think, only together enable and to examine and to understand why some states are more protective of some minorities than of other minorities. The Kimlicka reasoning, we should be more lenient when it comes to people to whom we have been imposing our laws than to the people that are, so the people we never asked to come and then they stay. So the kind of very brutal logic sometimes when the state is not willing to just show up some more leniency or show some more leniency for newcomers. My third question is what I see as convergences, as trends, but maybe I should think of more trends. And I confess I was listening with enormous admiration to the last presentation when it came to this externalization. But for not having been integrating this concept in my thinking, it may turn out that I will identify more trends. But three trends I see now is one that we have been also identifying in previous presentations, is in each situation you see something today of, on the one hand, globalization, and very often also hand in hand with increased individualization of lifestyles. People claim also their lifestyle as to be a right. The second kind of convergence is, and I will probably dig into this a bit further, is the increased role of the case law. For lack of clear policies, you see that this judge-made law is becoming ever more the atelier, so to say, of the legal reasonings in addressing cultural diversity. This kind of meticulous examination by judges that are bound to look for solutions that allow for the protection of cultural diversity. And the third convergence has to do with this underlying principle that you see popping up everywhere. It's the right to equality and non-discrimination. Of course, these trends go hand in hand. As I said, the efforts made by the courts over the past 20 years or so led on the one hand to, yes, grant identity claims the benefit sometimes of a minimum, sometimes of a more generous protection, while at the same time proving in certain cases to be particularly reluctant to cooperate in their extension. In practice, the scope of obligation on the part of states to respect cultural identity in terms of rights and liberties appear very often to depend on the specific circumstances of the situation at hand. It depends, and it may sound very unfair because it comes with huge legal uncertainty. It depends ultimately on how liberal the reasoning invoked by the judge hearing a case will be as to whether the identity claim indeed deserves to be taken into account. We did some comparative research when it comes to this technique of reasonable accommodation in the workplace. You can't believe the same scenarios being dealt in 10 different ways. So, you know, the picture is frightening because there is this uncertainty. And you have then all these cases that in all the countries all of a sudden become a national debate. Whether it was the Kirpan case in Canada, the dress code in the labor place or on the public place, all types of exemptions, conscientious objection. Can a civil servant have a conscientious objection in a secular state? Whether mitigating circumstances apply. And now in Germany, body marking, when it's for religious reason, it becomes a real problem. So we have this, and courts are faced and have to decide. And the third kind of trend is the principle of equal treatment that has gained momentum and monumentum over the past 30 years, especially, I'm not the one to think, but the observation, this growing success of the conception of equal treatment in liberal democracies, namely that equality must be blind to a person's identity characteristics, religious, cultural, otherwise, unless, paradoxically, the principle of equality were to yield the opposite effect on account of this blindness. And where does the result is the exclusion of the person. And in such a case, it may be even necessary to make an adjustment, an observation that has led to the development of the concept of so-called reasonable accommodation. And it is also true, however, that equality, in French we say, n'est pas la panacée. I don't know how you pronounce in English. It's not a panacea. It's not a solution out of itself. Equal is not enough, you could say. The divergences between the court's views on how to guarantee equal treatment and non-discrimination, these divergences in Europe, for example, can be explained in part by recourse to this so-called margin of appreciation you were referring to, which is the kind of standard expression used to refer to the space, the room for maneuver left to state authorities responsible for examining in each case whether an equal treatment is to be guaranteed. And this kind of margin of appreciation by some is being interpreted as the court is not courageous enough. It sends the case back into the national legal orders. But very often it's because the reason of the court is to say this is so much in the context of this country that local authorities have to take responsibility for this. Then minorities feel abandoned by the court because they say, but no, we claimed in Strasbourg because we disagree with the Italian government. So now we're sent back and now we're dependent. The advantage, of course, there was world media press attention for this case, so they gained something, but they remain dependent on this kind of, the margin of appreciation is in fact the technique we use in Europe to be Europe, but we also remain diverse. So this is, on the whole, one may say that the solution reached today most often on a case-by-case base to draw the line between, on one hand, what is justified differential treatment, and on the other, discrimination, the degree of restriction that is considered proportionate, that this way of handling these situations largely diverge among the courts, among the countries, among the levels of jurisdiction, which then brings with it the principle of legal insecurity. Has multiculturalism failed? Well, you have two positions. The one position is to say, in the end, the answer is in the hands of state authorities. And they decide, and the margin of appreciation lies in this line. The other is to say it should be different. It should be the people themselves that should be the standard. You should have a look first at the people, and the social cohesion is a lesser concern. So these are the two answers. And today, I think in law, it's the first option that prevails. In the end, it's state authorities that. I switch to you, Werner. How many seconds, how many minutes do you still give me?
So it is in between 7 and 8 minutes.
Well, then I will speed up. Just to say that courts are very often today faced with a real problem. That is how to protect identity, but what is identity? Because you have different ways to identify a person. Either you go for the subjective approach, a person that feels that she is intensifying her religious belief and asks for the protection of the intensification. For example, she did not claim the right to have the headscarf on her identity card last year, and nevertheless she claims it now. But there is an extra administrative cost that is the delivery of a new identity card, whereas she was supposed to only renew it in 5 years from now. Do you then just protect this kind of subjective identification with another version of her religion? The more objective, it depends on the language, it depends on your nationality. That is sometimes very, very rigid, too rigid. And then, of course, there is the multiplication of identities, people that sometimes feel citizens, sometimes feel believers, sometimes feel... So there is this kind... And the courts have a real problem in handling that. What we're doing now in Halle is we're starting a kind of collaboration with judges, and we have judges from 14 countries so far. And we would like to interview around 10 to 15 judges in each country with a kind of one questionnaire. How do they address these issues? And what would be a better support for them? No? Because very often they feel they're lonely riders. No? And would it be databases? Would it be experts? And just what I will say in 1 year from now, I can tell you which picture we get from this kind of meeting with very sometimes lonely judges. And we had pleasure in meeting with some of them in Brussels about 2 months ago. And there was this kind of, it's so strange, a very shy attitude at the beginning of the day. We were a full day together. Very shy, not wanting to make of cultural diversity a problem, because on the one hand that's not done, but on the other hand feeling that they have really difficulties in handling this, and then meeting with one another and recognizing one another's difficulties created a really productive day. And then you feel, I have to do something with this. These people can learn, but these people can also benefit from the kind of analytical work that we will then do. When I take a more forward-looking approach, I can be very brief on this. I think the whole debate about state intervention versus self-determination, I really think that, for example, like religious arbitration in the UK are good examples where you can try to find a terrain d'entente, where the judiciary remains the responsibility of the state, but granting much more space for religious communities to organize themselves. No? And I think of what you brought in, Pamela, what I'm fearing, for example, African communities in Berlin are not yet organized to offer these platforms, but the day they are, it would be good that people like your two respondents can go to these places, knowing that it is not in the shadow, but that it is being granted some kind of recognition under state law. I think, for example, in divorce proceedings, in Europe we have been abandoning the idea of reconciling the partners. No? This is against our new version of people decide, and no judge has to do the kind of moral play of remembering them that they better stay together. No? Now, in religious laws, this is a condition for a valid divorce. Why can't we just distribute responsibilities, that the attempt at reconciliation is done by a body, and if it fails, then they go to the civil judge? Because what the people now have to do, they have to divorce 2 times. No? They have to divorce before the religious and before the... So we could gain, all of us could gain, from kind of reciprocal trust. On the techniques of conflicts of law, I will be very brief. I mean, you, Nina, you should have been giving a kind of lecture on this. You're working so hard in Europe on bringing legal systems closer to one another, because the techniques of conflicts of law have also these kind of disadvantages, producing limping situations, conventions where in fact the states are more claiming the exception than the rule, so you just claim the convention to fall back on the exemptions. So, and I think it's such a difficult field of law as well. So maybe we need your testimony for bringing in how Europe is trying through private international law to find ways to come closer to one another. But in Germany you have two opposite views. On the one hand, and I really would owe him a tribute, was Eric Jane, who for years was very much going far as he could to make something like religious pluralism possible under German civil law. He was taken for some people by far too pioneering or a dreamer, but he went very far. And on the opposite, you have then Professor Basedow in Hamburg, who said, don't think of private international law to solve the problem of diversity within Germany, because this is another field of law. So you have these really two views, and we could dig into it. And then the personal autonomy now being taken, people should contractualize, people should decide for themselves which law applies. I go for that technique, but under condition that it is very democratically organized, that people know what are the options, that they can go for free legal clinics, giving them professional advice, and that people also may change their mind over time, because sometimes people regret their option, and then what do you do then? So I think personal autonomy. Let me finish by drawing a kind of conclusion. We face today, I think, a very new world with ever more intricate life paths. People combining, people regretting their previous identity, people changing even their gender, people change. There are all these things, and people claim that it is a right in terms of individualization of lifestyles. So how to accompany this when we think particularly of people having a kind of hesitation about whether they go for minority law, but they don't want to go definitely for minority law, they don't want to be encapsulated in minority law, they would like maybe... How can we just help people, accompany them without making them feel guilty about these intricacies of identity? And I think I will further elaborate in my written expose that it best be done with state domestic orders, and if possible also, of course, with the international courts that we have in Europe, but to handle this so that the people feel there is something like an effort made on part of the official bodies in a country where they live to come closer to them. You will make of them loyal citizens. They will feel much more. Now what people do is they move back to the so-called country of origin. Sometimes they never lived there, but they go nevertheless get a divorce there, or they still have havings there, but they don't want to tell here because it's being handled differently here, or there is this discriminatory inheritance laws, and so people don't really know how to handle. And when I see that there is a bit of work already done, and we should really, I think, the lawyers among us, we should go further in exploring how far you get with alternative dispute resolution, how far you get with personal autonomy, not just for your elites, how far you get with reasonable accommodation in the sense of inclusive even-handedness. The real kind of inclusivity can perfectly live with diversity, this kind of belief. I think that Germany has gone an interesting way with these kind of arrangements with municipalities, where Alevi people have, for example, their own arrangements, depending on the local needs, the municipality, and there you have this level of cultural diversity at a local level. I think, don't go the French way. I hope there are no French people in the room. No openness at all. If you want to know how not to do it, you read the parliamentary debates on the full veil, and you see that I think it's not the way to go, because you challenge these people to the point that then they go for a fine, and they're happy with the fine, because this mediatization of the victimization, and I think that is really not the way to. In private international law, I think there is really a vein in conventions, even also bilateral conventions, but then really in a relationship of trust, where the countries do not systematically feel the need to fall back upon the exceptions, which is then in the end to reject the other one's laws. And in criminal law, I had no time, but I really think we should go for mitigating circumstances, avoid abuses of the cultural defense. But what we should not do is what is now very much the case in Europe, is select out a number of practices and then criminalize them, so you get rid of the problem. You just penalize the full veil. Now you penalize, not yet, but female circumcision has been penalized. That's probably a thing that we can share. Please don't penalize boy circumcision, but there are some claims already. So you see, we just pick the kind of, this is bashing. And when you bash, you get what you deserve. All but a multicultural society. So I hope I'm not abused of, no?
No abuse at all.